Muldrow versus St. Louis is a 2024 decision from the Supreme Court about employment discrimination. The question that the Supreme Court answered is, how much harm do you have to suffer to have an employment discrimination claim under Title VII? Back in 1964, Congress passed the Civil Rights Act, which includes many provisions divided up into several titles. Like the Equal Protection Clause of the 14th Amendment, Title VII tries to eliminate considerations of race, sex, and ethnicity from the law, specifically in the context of employment discrimination. In Muldrow versus the City of St. Louis, Sergeant Muldrow alleged that her employer, the St. Louis Police Department, violated Title VII by transferring her to a new department simply because she's a woman. The lower courts dismissed her claim, though, on the basis that even if it's true that she was discriminated against, she hadn't suffered any significant harm. Her title, salary, benefits all stayed the same after the transition, so the lower courts held that she didn't have a claim. True, her schedule changed, and she lost access to her employer-provided car, but these harms the lower court held were too small to count. They were, in the words of the Eighth Circuit, only minor changes in working conditions. Now, the Eighth Circuit was not alone in holding that only significant harm counts. There was a circuit split between those like the Eighth that required significant harm and others that had no harm threshold. The Supreme Court, in a unanimous decision by Justice Kagan, sided with those other circuits, holding that an employee must show some harm, but that the harm need not be significant. That conclusion, the justices reasoned, flowed straight from the text of Title VII. Discriminate, the court reasoned, means treat someone worse, which implies some sort of harm but does not set a threshold on the amount of harm. In other words, harm is required, but any harm will do. So the Supreme Court reversed and remanded the case back to the lower courts to consider whether Sergeant Muldrow suffered harm. Although all the justices agreed with that result, a few filed concurring opinions. Justice Thomas wrote that he was not convinced that the lower court applied the wrong standard. It appeared to him that the lower court actually applied the right standard, even though it didn't describe what it was doing precisely. For his part, Justice Alito described the majority's opinion as unhelpful because it creates a vague and unpredictable test. And finally, Justice Kavanaugh concurred on the basis that any race, sex, or religious discrimination satisfies the harm requirement because, and I quote, "the discrimination is the harm." Regardless, he said that harm will always be satisfied under the majority's test because harm can be shown easily by money, by time, satisfaction, schedule convenience, commuting costs or time, prestige, status, career prospects, interest level, perks, professional relationships, networking opportunities, effects on family obligations, or the like. In practice, I think Justice Kavanaugh will be proved right. If there is no threshold on harm, then any change in employment condition that is even a little bit worse will count. So in this case, losing access to an official car is certainly worse than having one. Will the case mean more employment discrimination cases? I see no reason why it will increase the number of employment discrimination cases, but it will make it easier for employees to win them. Again, I think that functionally the harm requirement is nullified because worse, like Justice Kavanaugh says, is always going to be subjective, and without a threshold, any subjective sense of worseness is going to be enough to satisfy the harm requirement. Employment discrimination cases are very common, and there are a host of related legal issues that could find their way back to the Supreme Court. One which is ripe for litigation is a lesser-known part of Title VII, which makes it illegal for employers to label, classify, or otherwise group employees by race, ethnicity, religion, sex, etc. With the proliferation of diversity, equity, and inclusion practices at many employers, we've seen the creation of things like affinity groups, training programs, and we've even seen hiring and firing decisions made on those protected bases, all of which seem to run afoul of Title VII. And sure enough, there are many such cases percolating through the lower courts now. Muldrow is likely to open the door to a whole new range of employment discrimination cases.